Alright, welcome to recorded lecture for Company Law of Papua New Guinea. This is topic 5, Membership Rights and Meetings. This is part 1 of the recorded lecture. Let's start off with the meaning of shareholder. So, according to the Companies Act, shareholders are persons whose name is entered in the share register as the holder of, or for the time being, of one or more shares in the company, or until the person's name is entered in the share register, a person named as shareholder in the application for the registration of the company at the time of registration of the company, or until the person's name is entered in the share register, a person who is entitled to have that person's name entered in the share register under the registered amalgamation proposal as a shareholder in an amalgamated company. The liability of shareholders discussion is talking about whether the shareholders will or will not be liable. If there is an obligation incurred by the company, shareholder is not liable. By default, the liability of shareholder is only limited to their contributed capital, except where the constitution of the company provides that the liability of the shareholders of the company is unlimited. Nothing in this section affects the liability of shareholder to the company under a contract, including a contract for the issue of shares or for any tort or breach of fiduciary duty or other actionable wrong committed by the shareholder. With regards to former shareholder, by default, the shareholder related to shareholders. But after ceasing to become or to be a shareholder, any liability incurred by the company will not make the former shareholder liable. So which means after the former shareholder ceased to be a shareholder, no more liability for him if the company had incurred liability after that event. Where a person ceased to be a shareholder of the company before the liability of the shareholders of the company ceased to be limited and become unlimited, and that person has not since become a shareholder of the company, that person is liable to the company only to the same extent as if the liability of shareholders had remained limited. So if the company changed from limited to unlimited company or limited to unlimited liability company, the shareholder or the former shareholder will only be liable as if the company remained to be a limited liability. So which means before it becomes unlimited, whatever the status of the liability of the shareholder will remain the same. For the purpose of this discussion, a specified period means a period of 1 year before the commencement of the liquidation of the company, and in the case of the company that has been put into liquidation by the court, the period of 1 year before the making of the application to the court, together with the period commencing on the date of making of that application and ending on that date on which the order was made. Now, with regards to shares, this is the definition under section 37 on shares, on what are the attached rights to that share. Okay, the following are the rights mentioned. The first one is the right to one vote on a poll at the meeting of the company on any resolution. So which means if you have a share, you have the right to vote. Then the right to an equal share in dividends authorized by the board. So the number of, or the amount of shares that you will be receiving if you are a shareholder will be based on the number of shares and based on the percentage of the outstanding shares of the company. The right to an equal share in distribution of surplus assets of the company, especially when there will be excess of assets, okay, for the company. Of course, we're talking about net asset. These are classification of companies where companies are issuing shares. So the first classification is companies limited by shares. The other one is unlimited liability companies, no liabilities company, liability companies, and companies limited by guarantee. Now, as we discussed a while ago, when you had the shares, or the share is, you own the share, you have certain rights that you can exercise within the company. So the first one is the right to one vote on a poll at a meeting of the company. This includes appoint or remove a director or auditor, adopt a constitution, alter the company's constitution where it has one, approve major transaction, approve amalgamation of the company, put the company into liquidation. So these are the rights of every shareholders with regards to company. And again, you have the equal right to receive dividends, again based on the number of shares, and your share on the distribution of the surplus assets of the company. In appointing and removal of directors, okay, that is one of the rights of the shareholder. They can vote to appoint or remove directors. Now, under Section 129 of Companies Act, to be appointed as director, there are certain qualifications. The first one is be a natural person, not a company. So that's important. To become a director, you must be a natural person, not a legal entity. If you can recall what we have discussed about the legal entity, company is a legal entity, but they are not supposed to be a director. Then consent to the appointment in writing in the form or prescribed form, and certify that he or she is not disqualified from being appointed or holding office as a director of a company. Over 18 years of age, or the legal age, not be a person who is prohibited from being a director or promoter of, or being concerned on taking part of the management of the company. Not be a person who is or becomes unsound mind. We don't want directors to be insane and running or having that position. In relation to any particular company, not be a person who does not comply with any qualification for directors contained in the constitution of the company. So the company themselves can set a particular requirement or qualification when they elect directors. It should be noted that lawyers, accountants, receivers, and other people acting in their professional capacity by giving advice are not directors, so long as they act only in their professional capacity. So which means if you are the lawyer or the solicitor or the auditor that providing your professional work to the company, you are not part or you are not treated as a director if you're acting within your professional capacity. A de facto director is one who carries out functions or the functions of a director but has not, for some reason, been validly appointed. This is what they call shadow directors, okay, who in fact direct a company but do so by directing those on the board. They are not officially the director, but they had an influence on those who had been assigned as part of the board. Now, how to remove a director? Again, it is subject to the constitution of the company. The directors can be removed from office by ordinary resolution or for the purposes or special resolution that includes the removal of the director. If they call on the meeting, an ordinary resolution can be passed and they can remove the directors, or they can call for that purpose on voting of the removal of the director. The notice of the meeting referred to subsection 1, which you can see on top, shall state that the purpose of the meeting is the removal of the director. They can state that in their meeting the purpose of why they have the meeting on removing the director. Director's duties includes duty of director to act in good faith and in the best interest of the company. This is important. So when the directors, because of their oversight power, they have to act in good faith. And when you say best interest of the company, they always ensure that the company's interest or the best interest for the company will be first before anything else. Exercise of powers in relation to employees. Nothing in section 112 limits the power of the director to make provision for the benefit of employees of the company in connection with the company ceasing to carry on the whole or part of its business. So the definition here by employees, it says it includes former employees and dependents of the employees or former employees, but does not include an employee or former employee who is or was a director of the company. The company stated here, it includes the subsidiary of the company. Director's duty of care. Now, if the director, while they are exercising their powers, shall exercise care, diligence, and skill that a reasonable director would exercise in the same circumstances, taking into the account, but without limitation, the nature of the company and the nature of the decision and position of the director and the nature of the responsibilities undertaken by him. A director who acts in contravention of this section commits an offense and is liable on conviction to the penalty set out in section 413, subsection 4. This is important to take note. It says, or requiring the directors to exercise care, diligence, and skill that a reasonable director would exercise. When you expect or expecting something from them, that they will exercise their work in a diligent manner, and then they have the required skills that we are expecting for a reasonable director. Use of information and advice. Subject to subsection 2, a director of company, when exercising or performing duties as a director, may rely on reports, statements, and financial data and other information prepared or supplied, and on professional or expert advice given by any of the following persons: an employee of the company whom the director believes on reasonable grounds to be reliable and competent in relation to the matters concerned. A professional advisor or expert in relation to matters which the director believes on reasonable grounds to be within the person's professional or expert competence. Any other director or committee of directors upon which the director did not serve in relation to to matters within the director's or committee's designated authority. Let me cite few examples on this. When you talk about an employee who believes on reasonable grounds to be reliable and competent, we are talking about persons who have proven their competency or maybe a certified person who can perform the work. So if we are requesting financial statements, we are relying on the financial statements prepared by a CPA. Now on letter B, professional advisor or expert, when we are talking about or requiring legal advice, when we talk about a professional lawyer, we are relying on what they advise us because they are expert on law. That's our assumption. And letter C, it talks about any other director or committee of directors, or we call it committees or subcommittees. Now if the company had created a committee, for example, financial risk committee, they're expecting this committee to be focusing on the risk management or helping on the risk management practice of the company. Okay, subsection 1, the previous one applies to a director only where the director acts in good faith and makes proper inquiry where the need of inquiry is indicated by circumstances and has no knowledge that such reliance is unwarranted. A director of company shall, forthwith after becoming aware of the fact that he is interested in the transaction or proposed transaction with the company, cause to be entered in the interest register, and where the company has more than one director, disclose to the board of the company where the monetary value of the director's interest is able to be quantified, the nature of the monetary value of that interest, or where the monetary value of the director's interest cannot be quantified, the nature and extent of that interest. This is actually protecting the company against a director who will be acting in bad faith. So it's in a situation where there is a conflict of interest and the director opted to act on his benefit, or may be acting with in favor of his benefit. Now, to avoid that, they have to disclose the monetary value and interest, and if the company will benefit from it, then the board has to know first and then ratify. Again, we are not prohibiting director to transact within the company, but they should act within, or they should act in good faith and always choose the best interest for the company. For the purposes of subsection 1, a general notice entered in the interest register or disclosed to the board to the effect that a director is a shareholder, director, officer, or trustee of another named company or other person and is to be regarded as interested in any transaction which may, after the date of the entry or disclosure, be entered into with the company, that company or person, is sufficient disclosure of interest in relation to that transaction. A failure by director to comply with subsection 1 does not affect the validity of the transaction entered into by the company or director. Every director who fails to comply with subsection 1 commits an offense and is liable on conviction to the penalty set out in subsection 413, subsection 2. All in all, this is only talking about the transparency of the transaction made by a director with the company. And at the same time, again, it is testing what is the best for the company and if the director is acting within or acting in good faith. Interested director may vote. Subject to the constitution of the company, a director of a company who is interested in transaction entered into or to be entered into by the company may vote on a matter relating to the transaction and attend the meeting of directors at which a matter relating to the transaction arises and be included among the directors present at the meeting for the purpose of a quorum, and sign a document relating to the transaction on behalf of the company, and do any other thing in his capacity as a director in relation to the transaction, as if the director were not interested in the transaction. Now, if there is a transaction and where the director is interested or have an interest on that transaction, they can still vote and attend the meeting and even sign the document on behalf of the company and do his work within the capacity as a director. It is not really prohibited, again, as long as the transaction will benefit or will have the benefit for the company and there is no act or bad faith act from the director, so meaning they provided the proper disclosure, then the transaction entered into will be valid. That ends my presentation for part 1 of this topic. For topic 5, membership rights and meetings. For the next lecture, we will discuss the second part of topic 5, membership rights and meetings. That is part 2. Thank you.